Item 20.
Prerna Jhunjhunwala for the appellant and Mr. Yuvraj Roy for the respondent. आपके साथ कोई है? Mr. Tarun Kumar. This appeal has been filed against the judgment dated 11 February 2019, passed by Principal District Judge West Indian at Jaipasa in Civil Appeal number 14 of 2018, whereby the appeal filed by the appellant has been dismissed. The order impugned was passed. The order was passed by the learned executing court, which is dated 13/12/2018 in mysterious civil application number 49 of 2018, arising out of execution case number 20 of 2016. By the court of learned civil judge in bracket civil division number 1 bracket 2 at Jaipasa, whereby the learned court, the learned executing court dismissed the petition filed by the appellant/objector under Order 21, Rule 97 and 99, read with Section 151 of Code of Civil Procedure. This appeal was admitted for final hearing by order dated 13/5/2019. The substantial questions are quoted as under. The learned counsel for the appellant, while assailing the impugned, the learned counsel for the appellant has submitted that appellant was not a party in the partition suit and had filed a petition under Order 21, Rule 97 and 99 of CPC and claimed independent title. It was the claim of the appellant that he was in possession of the property having area 27 feet into 9 feet 2 inches, total 248.4 square feet, which was only a portion of the property allocated to the decree holder. Portion है ना उसका? Entire property?
Decree holder was only allotted 19 feet into 8 feet, which is 152 square feet. And the pleader commissioner has given a report stating that I am in possession of 27 feet into 9 feet 2 inches. This was also a contention that we had raised. The pleader commissioner himself has given a report which is erroneous.
Achha, just a minute. This will be 27 feet into 9 feet 2 inches is equal to 248.4 square feet. The learned counsel submits that the area claimed by the objector was more than the area allocated to the decree holder. She submits that once an independent title was claimed, the executing court ought to have given an opportunity to lead evidence in support of the claim and was not justified in rejecting the claim in a summary manner. She has also submitted that an adjudication under Order 21, Rule 97 and 99 of CPC assumes the character of a decree, and therefore the petition could not have been dismissed in the manner it has been done. This means that even the appellate court has not considered this aspect of the matter. The Learned Council has submitted that the Learned Executing Court as well as the Learned Appellate Court have placed reliance on the Pleader Commissioner's report, which was conducted by the Commissioner prior to passing of the decree, wherein no such possession of the petitioner of the appellant as of the objector as claimed was reflected. The Learned Council submits that that at the stage of execution, the report of the Pleader Commissioner reflected that the property was being occupied by the objector. The Learned Council has submitted that the appellant was admittedly not a party in the partition suit, nor was a family member of the persons who were party in the partition suit, nor was claiming title from any of the parties in the title suit, either prior to passing of the decree or even after passing of the decree. The objector was claiming independent title and primarily claiming adverse possession for last 50 years. She has submitted that by the order dated 21/1/2025, the records of the executing court was called out, was called for, and even the records of the executing court does not reflect granting any opportunity for legal defense. She submits that after the objection, the reply was sought for, and thereafter the order in June was passed by the Learned Tribunal. The Learned Council has relied upon the judgment passed by Honorable Supreme Court reported in
2015 1 SCC.
Graphic 2015 1 SCC 379 para
17,
para 17
para 25,
17 25 and
26.
26, and has submitted that in paragraph 25 the earlier judgment passed by Honorable Supreme Court reported in bracket 1997 bracket 3 SCC 694 dealing with the nature of objection under order 21/99 has been delivered. The Learned Council submits that both the substantial questions of law are fit to be answered in favor of the appellant and against the respondents, and the review judgments be set aside and the matter be remitted to the court concerned for due adjudication of the claim of the appellant. The Learned Council has submitted that she has no objection if any date is fixed by this court for appearance of the parties, and she has also submitted that the appellant would cooperate with the expeditious disposal of the matter and will not seek unnecessary adjournment, keeping in view that the partition suit is of the year 1984. The Learned Council, appearing on behalf of the respondent has opposed the prayer and has submitted that on the face of the petition of objection filed by the appellant before the executing court, even foundational fact regarding claim of adverse possession was absent. We have submitted that no document was produced to show that the objector was in possession of the property. The learned counsel has also submitted that there is no reference of any act of possession of the property involved in this case. The learned counsel has also submitted that the petition was a frivolous petition and was primarily with a view to deprive the decree holder of the fruits of the decree. The learned counsel has also submitted that not all the petitions filed at the stage of execution calls for adjudication, and it is open to the executing court to dismiss such petition at the very initial stage. If prima facie the court finds that there was no substance in the petition, in such a petition, and such a petition can also be dismissed without registering the same as a miscellaneous case. For this, he has relied upon the judgment passed by this court reported in 2014 SCC Online Jhar 2937 within bracket Nan Lal Sharma versus Rajkumar Sharma, para 6. The learned counsel has also relied upon the judgment passed by Honorable Supreme Court reported in bracket 2004 bracket close 10 SCC 779 and has referred to paragraph 11 thereof to submit that the basic ingredients of a plea of adverse possession has been enumerated therein, and a person who claims adverse possession should show A. On what date he came into possession, B. What was the nature of his possession, C. Whether the factum of possession was known to the other party, D. How long his possession has continued, E. His possession was open and undisturbed. He has also submitted that a person pleading adverse possession has no equities in his favor. In the present case, the objector is not claiming independent title through any instrument or through inheritance. Rather, the specific case of the objector was with regard to adverse possession. The learned counsel has also relied upon the judgment passed by Honorable Supreme Court reported in bracket 2015 bracket 1 SCC 379 paragraph 17, 25 and 26. ये तो आपने रिलाई किया है 2050. You have relied on 2050?
No.
I had relied.
You have
I have relied on 21.6.
just has relied upon ये वाला हटा दीजिएगा. Has also relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2021 bracket 26 SCC 418 Rahul R. Shah versus Jigin Kumar Gandhi and others. Paragraph 24, 25, 25 4 to 35 to submit that the Honorable Supreme Court has taken note of the fact as to how the fruits of the execution do not reach the litigants, the fruits of the decree do not reach the litigants, and also submitted that the Honorable Supreme Court has observed that such obstructions for execution could be avoided if a court commissioner is appointed at proper time. The learned counsel submits that in the present case, the court commissioner was appointed at proper time, that is prior to passing of the decree, and his report did not find presence of any third party over the property, including that of the appellant, and therefore there can be no doubt that the petition filed by the appellant is frivolous in nature. That's all.
One additional submission was the respondent, if your lordship, she is a lady of now 70 years. She will not be able to enjoy the degree.
The learned counsel has also submitted that the respondent is around 80 years of age,
70.
is a senior citizen and has been fighting, and the title partition suit is of the year 1984, and if the objection without foundational facts are entertained, then she will be completely deprived of the final decree which has been passed in the year 2016.
Final decree of 2008.
Final decree which was passed way back in the year 2008. The appeal was, इसका अपील भी हुआ था फाइनल डिग्री का
No.
2008 से एग्जीक्यूशन तो नहीं चल
नहीं, बाकी कोस्टर्स अपना शेयर ले लिए. It is only the respondent that अपना शेयर वो नहीं ले पाए. बाकी सब ले लिए.
The learned counsel has also submitted that the other co-sharers of the property have taken their respective shares in terms of the decree in the partition suit, and this old lady has been deprived of
The share allotted.
the share allotted. After hearing the learned counsel appealing on behalf of the parties, this court finds that the appellant had filed a petition under Order 21 Rule 97/99 with Section 151 of CPC in the execution case arising out of title partition suit number 161 of 1984, claiming allotment of area with respect to 27 feet into 9 feet 2 inches is equal to 248 on 4 square feet. Admittedly, the appellant was not a party in the suit proceedings, nor it is claiming through any of the party, nor is a family member in the partition suit. The records, this court has perused the records received from the executive court and finds that the executing court rejected the executive court instituted the case the objection filed by the appellant as miscellaneous civil application number 49 of 2018 and called for a rejoinder from the decree holder, and after hearing both sides, straightaway rejected the petition by order dated 13/12/2018. The finding of the learned executing court is as under page 33 का portion court का, ठीक है? यहाँ से after hearing both sides. The perusal of the aforesaid order rejecting the petition reveals that the executing court has referred to the Pleader Commissioner's report, who had submitted his report in title partition suit number 1 of 1984. Wherein an area of 561.8 square feet and open plot 19 feet into 8 feet was allotted to the defendant number 10 therein, that is the respondent herein, and the learned executing court has rejected the petition by referring to the fact that in the Pleader Commissioner's report no encroachment was mentioned. The learned trial court also recorded that the objector himself admitted in his petition that he had acquired the title by way of reverse possession, but he had not submitted any bit of paper in respect of the suit land, and that the decree holder had contested the suit since 1984. And when the fruits of decree has cropped up, the objector filed his petition without any witness stand. The learned trial court primarily based its finding on the report of the Pleader Commissioner dated 24/2008, which was filed in the title partition suit, and held that the report itself falsified the version of the objector that he was in possession of the property since last 50 years. The appellate court also based its finding primarily on the aforesaid report of the Pleader Commissioner, and recorded that there was nothing in the petition filed by the objector which suggested that which portion of the property was in his possession out of the suit property, and further no sheet of paper was there to suggest as to how and when he came into possession of the land in question, and that the decree holder cannot be deprived of the fruits of it. This court finds that the objector having filed his objection, and this court has gone through the objection filed by the objector, before the executing court. and finds that at the stage of execution, there was a report given by another pleader commissioner who had recorded the presence of the appellant on the spot. The objector had claimed that he was in possession of the area as reported by the pleader commissioner at the stage of execution. Since the lifetime of his father, approximately about more than 50 years, and the perusal of the petition so filed by the objector reveals that he claimed that this alleged area is attached with his residential house over survey plot number 169 and the khata number 67 of Mauza Chaibasa Nagar Palika ward number 7 corresponding to Chaibasa town Khas Mahal holding number 694 Khas Mahal plot number 2582, and that they were in possession of the property within the notice and knowledge of the parties to the suit, including the decree holder, and his right had fully matured into a title by adverse possession, and that he could not be disturbed, and he was the rightful owner of the property. The fact that the decree holder had filed a rejoinder to the petition. The petition was entertained by the executive court and was numbered as civil miscellaneous application number 49 of 2018, and the decree holder was called upon to respond to the petition, and the fact that the subsequent pleader commissioner at the stage of execution had reported that there was encroachment over the property was not in dispute. This court is of the view that the learned trial court, this court finds that the basic pleadings in connection with claim of adverse possession was stated in the petition, in the objection filed by the appellant, and the learned trial court had already entertained the petition and had called upon the decree holder to respond to the same. However, the learned trial court relied upon the pleader commissioner's report, which was filed in the title partition suit, in which no encroachment was shown, and the learned trial court recorded that no sheet of paper was filed in support of the claim. This court is of the view that the question of producing evidence this court finds from the records that after the petition and calling for the rejoinder, straight away the objection was dismissed in a summary manner and no opportunity was granted to the appellant to read evidence in support of his contentions. There is no such law that adverse possession cannot be proved by oral evidences. There is therefore non-production of kit of paper by itself would not be a ground to dismiss the plea of adverse possession. This court finds that the report of the pleader commissioner, which was filed at the stage of the correctness of the report of the pleader commissioner, which was filed at the stage of partition suit, is not binding upon the petitioner, and therefore the impugned judgment, order/judgments could not be based on such a report. The appellant, the objector certainly had a right to cross-examine the pleader commissioner on the report which he had furnished at the stage of partition. And such an opportunity was never granted to the appellant, as no evidence was led, no opportunity to read evidence was granted, and the petition was dismissed in a summary manner. These aspects of the matter have also not been considered by the learned appellate court. So far as the judgment which has been relied upon by the learned counsel for the respondent, reported in bracket 2004, bracket close 10 SCC 779, para 11, dealing with the basic ingredients of the plea of adverse possession is concerned, this court finds that upon perusal of the petition filed, the basic ingredients are more or less satisfied, and the establishment of such ingredient would certainly depend upon the evidence that may be led by the parties. However, such an observation is being made in view of the arguments advanced, and it will certainly be for the court concerned to last one. So far as the judgment reported in bracket 2021 bracket 06 SCC 418 is concerned, this court finds that it is true that decree holders are facing difficulty in getting the fruits of the litigation, fruits of the decree. However, at the same time, the claim of a person who is not a party to the suit is certainly required to be decided in accordance with law. There is no doubt that the obstruction for execution could be avoided if the court can be avoided if a court commissioner is appointed at proper time. And in the present case, the court commissioner was certainly appointed at the stage of partition suit. But the report of the court commissioner cannot be said to be a gospel truth, and the appellant has all right to cross-examine the commissioner on the report which was filed, if so required, as the appellant is claiming to be in possession of the property since last 50 years. So far as the judgment passed by Honorable Supreme Court reported in 2014 SCC Online Jharkhand 2937 is concerned, there is no doubt that if a court finds a petition to be frivolous, it can be dismissed at the threshold. But in the present case, the petition was entertained, a rejoinder was called for, and the case has been dismissed primarily by referring to the pleader commissioner's report, which was called for at the stage of participation. And essentially, the court has dealt with the merit of the case by referring to a pleader commissioner report in the title suit in which the appellant was not a party. Therefore, the aforesaid judgment relied upon by the respondent does not apply to the facts of this case. इसका जो पिटिशन है मैं इसमें से थोड़ा सा कॉपी करना है पैराग्राफ्स. Considering the totality of facts and circumstances, this court answers the questions of law in favor of the appellant and against the respondent, and accordingly the impugned judgments passed by both the courts are hereby set aside. However, the claim of the appellant is required to be adjudicated by the executive court, and considering the fact that the respondent is an old lady and the partition suit is of the year 1984, the parties are directed to appear before the executive court on 10th of March 2025. You will produce the memo of evidence
On that date.
Yes, certainly. And the appellant shall produce the memo of evidence, both oral and documentary. ऐसे ही होता है ना? Produce. क्या?
Oral documentary, list of documents, documents.
List of documents and the list of witnesses. On 10th of March itself, by serving a copy upon the counsel for the respondent who would appear on that day. Fresh wakalatnama file. The counsels to file, the parties to file fresh wakalatnama. And upon their appearance, the learned executive court shall proceed and decide the matter, decide the objection without giving unnecessary adjournments to the respective parties, and the final order be passed as expeditiously as possible.
Some time frame.
As expeditiously as possible, and endeavor be made to dispose of the objection within a period of 3 months from the date of the done? This appeal is accordingly disposed of.
It's liberty to the respondent also to adduce evidence if required.
Certain. तब बोलना पड़ेगा क्या?
पता है बहुत सारे होता है कि नहीं आपको तो लिबर्टी नहीं था
नहीं।
बोला.
It goes without saying that the respondent, that is the decree holder, shall also have the opportunity to adduce evidence in accordance with it.
Right.
Item 18, SA 222 of 2018.
कहाँ चले गए? आइए कहीं किसी कोर्ट में बुलाइए उनको. आज ये एडजर्न नहीं हो, आज ही हो, बुला के लेके आइए नेक्स्ट केस में. एक और पास हो गया
Yes, sir. From bill list item 7, SF 41 of 2023.
yes.
I was going through the record.
Sorry.
I was going through the record of the civil appeal. The flag that has been marked at page number 7 of the civil appeal. There's a mention of a first appeal. FA 95 of 2000.
Yes.
I've seen the online case number. It appears that petition was appealed in this matter.
In this matter.
In the first appeal 95 of 2000, through which the title of the vendor of the appellant has been
I don't know the guy.
Flat.
This one.
that pink flag.
This one. This one.
The
This one.
page 7.
Last one.
क्या particular number बताइए?
Lekha
FA
Devi,
95 of 2000.
Lekha Devi and another versus Sushila Devi and others. Lekha Devi and another are the.
होगा. I just do not know. I don't remember.
I was just going through them.
और कुछ copy है?
एक
मेरा नाम है तो बात खत्म है. फिर क्या करना? Not before me करना. कहाँ का जमशेदपुर? Not before me. Oh. Yes. Thankfully that you have told me. Otherwise, this creates a problem.
Yes,
I was for your party or the other party.
for the,
Anyways, that doesn't matter. But
I
still,
mean, there were a lot of parties.
For
So
one of
it is
them.
difficult to.
Item 26, second
आज
appeal
आप बच गए.
243 of 2019.
बच नहीं गए. एक मौका आपका चुप गया. अब अगला फाइल के लिए तैयारी है. हम आपको टाइम पास ओवर कुछ नहीं देने वाले हैं. हाँ. कौन सा नॉट टुडे? क्यों? ये नॉट टुडे क्यों? अरे अभी बहस करके कर. नहीं.
इसीलिए उसी में प्रिपेयर थे, इसीलिए
नहीं,
बोले कि
कुछ
यार
नहीं.
इसमें पासवर्ड
उसी
फॉर
में
द
प्रिपेयर थे और इसमें प्रिपेयर नहीं.
पासवर्ड फॉर द टेबल
ऐसा नहीं. इसमें भी ऑर्डर 21 रूल 99 का सेम केस है.
इसीलिए
पढ़िए पढ़िए ऑर्डर पढ़िए. ऑर्डर पढ़िए. अभी तो किए हैं ऑर्डर. बहुत सेम टू सेम है क्या? इसमें भी यही किया है क्या? पढ़िए. ये तो पूरा एविडेंस लेकर राइट. इसमें हम आपको टाइम देंगे. ठीक है. हमको पता है आप बहुत सारे केसेस कंडक्ट करते हैं, है ना? गलत पता है क्या? गलत नहीं पता है ना? चलिए पढ़िए. चलिए आप एपेलेट कोर्ट पढ़ लीजिए पहले इंग्लिश में. राइट.
पेज नंबर 19 in this case appellant is a petitioner and appellant present
Simply
appellant
facts directly.
yes, as per penal degree further of the respondent was allotted 0.205
नहीं पैरा 2 से पढ़िए. द ब्रीफ फैक्ट्स.
yes, the brief facts leading of the file of the present appeal that the father of the respondent has filed a partition suit number 99 of 1995 considered as a co-sharer of plaintiff of property. In that case, preliminary decree passed on 30/1/1998, and thereafter final decree was passed on 30/3/1999, and the report of Leader Commissioner was made part of final decree. As per final decree, father of the respondent was allotted 0.205 acre of land of plot number 171 operating Khata number 179 under Khewat number 114/3 of village Madhupur on situated site along with other plot, and remaining area was allotted to Iku Oram, disease in the partition suit. The respondent plaintiff filed execution case number 4/1999 for institute of final degree passed on 30/1999 in partition suit number 19/1995. Further case of the appellate is that the suit land was settled through Chaparbandi right in favor of Srimati Saraswati Devi by Chotka Mahadev Bora, the ancestor of respondent. On 26/1946. On the basis of such settlement, Srimati Saraswati Devi come in possession of the suit property regularly, paying tax and obtaining receipt thereof. Srimati Saraswati Devi executed a registered deed of sale to appellant on 9/6/1964. The valuable consideration. It is further case of the appellant is that immediately after purchase, she came in possession of suit property and constituted a building with investment of rupees 7 lakhs. She also dug a well and instead used hand pump as well as took water and electricity connection. In course of construction Ranchi Improvement Trust visited the site in 1965 and instituted a criminal case for unauthorized construction, which was registered as C1113/65, in which the appellant appeared and was enlarged on bail. As such, the appellant has got absolute right, title, and interest over the suit property. It is also contended that the respondent filed SAR case number 389 with 4 and 5. The restoration of land in his favor under 71A of Chodnagpur Tenancy Act. As a matter of fact, the present appellant, who was not the party to the partition suit, therefore the judgment rendered in that case is not binding upon her. The respondent in the curve of execution case number 4/1999 was trying to dispose the appellant, as a result of which the appellant has filed miss case number 4/. The said miscellaneous case was dismissed as stated above, hence this appeal. Case of the respondent as per shown, case filed by him. Miscellaneous case number 0/4/6 is that petition under order 21/99 and 101 read with section 151 CPC is not maintainable, as fact that the appellant petitioner by the said petition wanted to establish a right, title, and interest over the suit land. She would have filed a regular separate suit for adjudication her right, title, and interest over the suit land. Stranger cannot get his right determined in a petition under order 21/99 and 101 CPC. As a matter of fact, the appellant is claiming her right on the basis of Sada Bikrinama, which has no value in the eye of law. Moreover, delivery of possession has already been affected to the respondent with respect to the land and building as per Nazir report. the statement of the petitioner regarding delivery of subordinate position is totally false and concocted. In the light of aforesaid facts and following issue have been framed lower court in miscellaneous case number 6. Issue number 1, whether the petition of the petitioner is maintainable. Second, my lord, whether the petitioner has got right, title, interest and possession over the property. Third, whether the opposite party can claim the land after the period of limitation prescribed under section 48 of CLT Act. Fourth, my lord, whether the decree passed in partition suit number 99 of 1995 is binding upon the petitioner, whether the execution of the decree of opposite party was given actual possession of the property.
There is nothing. You are claiming on the basis of hukumnama. There is no rent receipt you have filed, right? And further in the SAR proceedings, it was held that the settlement in the year 1946 was in contravention of section 48 of the CATR. क्या क्वेश्चन ऑफ लॉ बनाएंगे हम इसमें? एक डेट बता दीजिएगा ऑब्जर्वेशन. The learned counsel for the appellant, Mr. Tarun Kumar Mehto, is present in the court. He submits that this case has to be argued by his senior, Mr. Rohitas Roy, who has left the court just after arguing one case. ये कैसा selectivity है भाई? He does not even have the courtesy to tell me that he doesn't want to do this case. He will run away from the court. हम तो ये लिखेंगे ना. This matter has to be argued by his senior. उनका नाम है, ठीक है? However, he has placed the impugned appellate judgment and has, upon perusal of which, it appears that the appellant was the objector. You were the objector, no?
Appellant petitioner.
Appellant was the objector to the execution of the decree and had filed a petition under Order 21, Rule 99 and 101, read with Section 151 of CPC. In execution case arising out of partition suit number 99 of 95. The objector claimed settlement in favor of Srimati Saraswati Devi by the ancestor of the respondent, as that was on 26/6/1946. The appellate court's judgment revealed that the hukumnama was a sada hukumnama and was not accompanied with and was further not supported by any rent receipt showing possession with respect to the property, and it also reveals that in a proceeding under section 71 capital A of Tobacco Tenancy Act, the property was directed to be restored to the respondent, and in the said order it was held that the settlement of the year 1946 was in contravention of section 48 of the prima facie, it does not appear that any substantial question of law is involved in this case. However, in order to give one opportunity for the concerned senior counsel to argue this case, close this case. अब 10:30 1:30 कुछ नहीं आएंगे तो हम कल जजमेंट लिखा देंगे. पास ओवर नॉट टुडे कुछ नहीं. कल आना है जब भी केस कॉल आउट हो बहस करना. ठीक है. चलिए for further hearing. It will be listed in the supplementary list और जल्दी ही चेकअप होगा.
Passover case item 19 WPC 1348 of 2017.
From the leadership on the ordership, matter was earlier adjourned because the state had preferred an LPA against the LPA has also been decided, though only on the point of limitation, so there is no merger.
So they have filed it.
Pardon?
They have filed the order of entry. कल देखते थे order of entry. और ये ऑफिस लगा दिया है.
So there is no merger, of course. On limitation, it has been dismissed, but
As it is, you are claiming that your case is covered by that.
yes.
Now let us see.
Well, it is the common 49 leases which were granted by the Tata Steel Limited sub-leases, which were approved by the state of Jharkhand, and subsequently, pursuant to certain audit objection, a status quo order was passed, and thereafter, it was challenged before this honourable court. The Lordship had directed that they had initiated an inquiry that will be conducted in a stipulated time frame, and then, the inquiry had been conducted, no order was passed. Thereafter, this court, had directed that the lease should be executed in the other hand. And it's exactly the facts are absolutely the same because it's
The
the common.
sublease should be executed.
Pardon? Sublease should be executed. And
Just
so if the other judgment ladyship may see, Ashiana Housing Limited, because facts are absolutely identical.
No,
There
we
is
will
not.
see. Ashiana Housing, right?
Yes.
Let's see the facts of this case first.
Yes. Okay. So, if you
Where
look,
is your lease deed? The lease is between Tata Steel and
yes, yes.
state.
Yeah.
You are claiming sublease.
Yes.
Any sublease was ever executed?
Yes, yes. Sublease was executed.
Where is that sublease?
Yes.
Give me the annexure number.
Yes. Annexure, first is Annexure 2, page 94.
What is annexure 1?
Annexure 1 is the sublease lease with, renewed for Tata Steel for a period of 30 years. Then, in that lease itself, there was a provision which was there with respect to sublease, and a mechanism was derived that how the
It
sublease.
was, what is the date of this lease, annexure 1?
Annexure 1 is 28/2005, which was with effect for 30 years, with effect from 1/1. If you want to see my list of dates, I think that will make things very clear, my lord. Of course, disputed. Page 2, if a ladyship may see. Annexure, I have given the details which are relevant.
Annexure 1.
Annexure 1 is post bifurcation of the state of Bihar and indenture of lease dated so and so was executed and registered in favor of Tata Steel Limited with effect from 1/1/96 for a period of 30 years.
This is expiring in 2026.
26, January 2026.
Still exists.
Still exists. Then appropriate machinery committee was set up by the state of Jharkhand by resolution number so and so dated 6/12/2005. Final decision on the recommendation of the appropriate machinery committee will be taken by the Revenue Minister Government of Jharkhand, and that such committee has been constituted for expeditious disposal of cases of sublease in terms of the cabinet decision dated 19/8/2005. So an appropriate machinery was constituted. Then the proposal of the petitioner for construction of 3-4 screen multiplex along with food courts and shopping malls of international standard was considered and approved by the appropriate machinery committee in its meeting dated 7/1/2006. Then additional Deputy Commissioner E. Singhum Jamshedpur by his proposal dated 1/2/2006 recommended the allotment of 3.12 acres of land at Circuit House area so and so to the petitioner at commercial rate of so and so at rupees so and so. Then the said proposal of additional Deputy Commissioner was approved by the Deputy Commissioner on so and so. Said approval was finally approved by Commissioner. Then state government by its order dated granted 3.2 acres of land to the petitioner, fixing the annual commercial rent of the land at the rate of 5% of the land at rupees so and so. So it approved up to the state government. Then Deputy Commissioner E. Singhum by letter directed Tata Steel to hand over the possession of the land to the petitioner, as petitioner had deposited the amount of so and so as annual commercial rent and cess. Tata Steel handed over possession of the sublease plot to the petitioner by letter dated so and so. Petitioner requested for relocation of the sublease site in view of the height restriction imposed by Airport Authority on the sublease site at Circuit House area. Request of the petitioner was forwarded by Tata Steel to Deputy Commissioner on so and so, and the proposal for relocation of Bistapur lease area was approved by the appropriate machinery committee. While ordered, again the relocation area was approved by the state government. Then, while order dated Deputy Commissioner Singhum and letter dated Tata Steel, the petitioner was directed to deposit annual commercial rent and road cess. Accordingly, an amount of so and so being differential of old payment and new deals were deposited. While letter dated Tata Steel offered sublease 3.1 acres to Bistapur lease area premises to the petitioner as per the order of the state government and accordingly handed over possession. An agreement of lease duly registered was entered into by petitioner and Tata Steel Limited on Itna for 3.212 acres of land in ward number so and so. Approvals from all the other concerned departments so and so were obtained thereafter.
Period? What was the period of this lease?
Yes, that I understood.
This is election 11.
Election 11. It is at page 122. It is still the expiry of the lease. The agreement shall remain valid till execution and registration of the deed of sublease. Have you got
Page number?
122. This agreement shall be deemed validity. Yes. This agreement shall be deemed to be effective from 22nd August. The agreement shall remain valid till execution and registration of the deed of sublease or 31/12/2025, whichever is earlier.
So this period is also over? No, it is yet to be over. 20. So thereafter what happened?
Then we applied for statutory clearance. Statutory clearance was granted. Airport clearance was granted. Fire clearance was granted. Pollution clearance was granted, and all clearances were granted. Then this is the impugned letter which was earlier impugned, Annexure 16.
Annexure 16.
Yes. While letter number so and so Tata Lease Bhumi Parishad dated so and so issued by Principal Secretary Revenue and Land Reform Department.
As a consequence of their aforesaid letter.
No, just
Oh,
above
no.
that, I'm sorry.
Yes,
Why
yes.
it is mentioned, I'm sorry.
Yes, yes.
As while letter dated so and so issued by Principal Secretary Revenue and Land Reform Department Government of Jharkhand addressed to the Commissioner Kolhan Division Chaibasa, it was communicated that in the light of certain irregularities committed in the matter of grant of sublease and also in the light of a report submitted by Debashish Gupta, the then member Board of Revenue Government has taken the decision to inter alia order the Deputy Commissioner E. Singhum to maintain status quo in the sublease plots under construction. As a consequence of the aforesaid letter, the Commissioner Kolhan Division wide letter dated forwarded the same to the Deputy Commissioner for information. Deputy Commissioner directed Managing Director Tata Steel to ensure stoppage of construction work on the plots allotted to the sublessees and maintain status quo. And Tata Steel thereafter asked the follow-ups. Then WPC so and so was filed challenging letter number so and so issued by respondent number 1 and consequential letter
This
dated.
order, where is this order?
Yes, Annexure 17, page 163.
Annexure.
That's the first order. May I read? May I just give the
You can
sequence?
just you finish the
Yes, I order dated an interim order was passed by this Honorable Court in similar matters in WPC directing the petitioners of the said cases to carry out further construction in their sublease area, subject to undertaking that construction activity will be carried out at their own cost and risk, and they will not claim any equity on that account. On so and so was initially not extended in the case of the writ petitioner. Petitioner filed an undertaking by virtue of the IA, it should be IA number so and so, why it's order dated, allowed interim order dated so and so to be in the case of the petitioner. We did not give that undertaking initially, but subsequently IA we gave that undertaking and it got continued. During pendency of WPC, petitioner filed an application requesting grant or renewal of building permit under reference and even offered to pay additional fees for renewal. By order dated, High Court allowed the writ application and left it open for the state government to conduct an inquiry in the matter and to complete it by 31st March by giving individual notice to the petitioner. After order of High Court, inquiry committee was constituted and a show cause notice was issued, which was duly replied by the petitioner. Further queries were raised by the inquiry committee, duly replied. Since inquiry was not completed, this is an important date. Since inquiry was not completed, an application was filed by respondent state for extension of completion period of inquiry. An Honorable Court by order dated passed in CMP and August extended time for completion of inquiry up to 30th June and made clear that no further extension of time would be granted for completion of inquiry. During pendency, a petitioner wrote a letter to regarding grant of deemed sanction of the building plan. But this is not important because it was ultimately granted. During pendency, petitioner was served a letter received on ITNA directing to stop construction. While letter respondent stated that then it is only on building plans.
That's right.
So then again, now my writ is, it was disposed of writ and then applications. So this is where the position is. The inquiry.
Just a moment. Letter dated such and such was issued during the pendency of 5952.
5952, the other earlier writ petition.
I see the writ petition 6138. Where is 5952?
5912 is the second writ petition, my lord, if your lordship may see, or ladyship may see.
In this list of dates, where is this? What was the cause of action?
Yeah, 5912 was filed for another, I'll just read that also. My lord, 5912, I'll just give that, 5912 was filed for that sanction plan they were not approving. Annexure page 224.
Petitioner was advised to withdraw the writ and file a composite writ.
But this is the first we had withdrawn this writ, we had filed for sanction of plan, and then we filed a composite writ, which is 1095, and
Where is the what prayer was there in WPC?
That I have quoted.
You must have mentioned it.
it was with regard to sanction of building plan. Just I'll just show it. Yes, Her Ladyship may kindly see para 49 at page 46. Page 40.
Page 45 is the quotation.
46.
Of the, para 45 is the quotation of the relief.
Yes, that is with respect to approval of building plan.
That's right.
Then we had withdrawn that writ petition, which is at para 49, because two letters were issued in the meantime by JNSC.
A letter was issued stating that it will be done only after the allotment of sublease in
If-
favor of them.
Yes, of course. It is basically
Your
registration.
sublease was cancelled.
No. Well, it's an agreement for sublease.
That's right.
It was not registered. We were given possession. Agreement for sublease registration is yet to be done. Was yet to be done. But we were put
The
in possession.
document that you have placed is not a registered.
No, it's an agreement for lease, notarized agreement for lease. So, my lord, my prayer, if your Her Ladyship may see, prayer number 3.
Yes.
To complete the formalities.
So basically, you are seeking registration.
Registration and no interference in the property in question.
If it is registered, you are bound. They are not. They cannot interfere.
But
Are they
otherwise
really
also they could not have interfered, but still they were interfering in one way or the other.
But fortunately, by virtue of interim orders,
Yes, we have constructed everything is there.
constructed and enjoyed the property.
We are enjoying and we are paying everything and what is there.
That's
And so, my lord, Her Ladyship may see the Ashiana housing judgment
Yes.
is exactly on the same point.
Let us see.
Yes. Both the writ petitions, may I read the facts little bit?
Yes. Yes.
Both the writ petitions have been preferred by the parties who have been allotted plot of land on agreement for sublease by Tata Steel, permission granted by JNAC for construction of commercial building. It is the case of Ashiana Housing that due permission was obtained for sublease in favor of the petitioner from state government, and upon receipt of approval of the settlement of land in favor of the petitioner by way of a sublease, Deputy Commissioner addressed to the directed the petitioner to deposit annual rent and cess. In same, my lord, Parikh is same.
That's right.
Petitioner's case, my lord, the facts is actually
Despite
absolutely the
permission,
same.
kindly read para 4.
4. Despite permission of sublease having an order of status quo has been communicated by Deputy Commissioner pursuant to a decision of the state government, consequently the execution of registered sublease has been stalled. Aggrieved by the non-execution of the sublease, the instant writ petition has been filed. Since both the cases involve common question of fact and law, therefore they are heard together and will be disposed of by the common order.
Let us see the findings.
Yes, findings are from page 6, analysis.
Yes.
The main question of law that falls for consideration in these matters is, can the state cancel or withdraw the consent for sublease already granted under clause 8 of the agreement in absence of any allegation of fraud or undue influence?
They have not withdrawn any consent.
So by virtue of stalling the process
Yes.
and restraining Tata Steel from registering the sublease, so the effect is that they are
That
wriggling out
that
of the
order by which the Tata Steel was
directed not to
stalled,
register. Yes.
registered
Ah.
is which document?
Is the document below which is read in the compilation, that follow-up documents.
So which letter is that? I want to read that letter. That letter is
Annexure
also
16, my lord, if your lordships may see, page 149 to 162 are the 11 letters. Tata Steel has only forwarded all these letters to us.
that's right. Where is that letter? Show us, which is that letter which restrains Tata Steel to execute the lease deed?
But 149 is the letter by Tata Steel to us, enclosing all the letters of the department.
That's right.
Then next page is Tata Steel. Kindly refer to your letter forwarding a list of 59 sublessees along with copies of letter dated so and so, principal secretary so and so, by the said company has been advised to has been directed to advise all new sublessees to stop construction with immediate effect. As directed by the effort, we have been advised to also to be guided accordingly. While we have acted immediately in deference to a directive, yet we have appreciated that had no reason for such abrupt decision taken by the government has been explained to us and the sublessees. And the further letters are at page 152. Page 153 is the Yathasthiti letter which will be status quo to be maintained.
Status quo in connection with construction?
No, construction अविलंब बंद करते हुए यथास्थिति बनाए रखी जाए. यथास्थिति is also with respect to registration. Construction to be stopped and further status quo to be
The entire
maintained.
document is just referring to the documents are only in relation to construction.
But kindly come to page 159. This is the letter of the state government, which is the genesis.
Where is that order where the inquiry was directed?
Inquiry was directed by this to be kept pending by the principal secretary's order.
Yes.
Page
Where is
159.
that order of the court? That some inquiry was to be conducted.
No, that's not the order of the court. That's the stand of the state.
Okay,
that
they are
we
conducting
stopped
some
that.
inquiry.
We stopped.
Where is that?
Yes, kindly wait. Page 159. Type copy is also there.
Yes.
उपयुक्त प्रासंगिक विषय के संबंध में कहना है कि टाटा कंपनी को अविजित बिहार आई स्किप दिस बिकॉज निर्णय लिख लिया गया.
That's right. Yes.
जिन मामलों में सबलीज बंदोबस्ती की प्रक्रिया पूरी नहीं हुई है उसे अविलंब रोक दिया जाए. स्वीकृत सबलीज के सभी मामलों में तत्काल निर्माण के संबंध से यथास्थिति बनाने का आदेश उपायुक्त दिया जाए जिससे कि भौगोलिक स्थिति में परिवर्तन ना हो. जिन मामलों में सबलीज की कार्रवाई पूरी हो चुकी है जिसकी समीक्षा की जाए. ऐसे मामलों में जिसमें सबलीज का औचित्य स्थापित नहीं हो रहा है उन मामलों से स्पष्टीकरण पूछकर लीज रद्द करने हेतु नियमकुल अभिलेख गठित करते हुए प्रस्ताव 10 दिनों में राज्य सरकार को उपलब्ध कराया जाए. समीक्षा के क्रम में ये देख लिया जाए कि जो सबलीज स्वीकृत हुई है उसमें से कौन कौन सा सबलीज मूल लीज के उद्देश्य के अनुरूप औद्योगिक नागरिकता है एंड कौन सी सबलीज निधि बिल्डर एवं मुख्य नीचे व्यवसायी में दी गई है. टाटा के साथ संपन्न लीज में ही सबलीज का प्रावधान किया गया जो लेसी की आवश्यकता अनुशंसा के अनुरूप की जानी. इस संबंध में टाटा कंपनी के सभी प्रस्तावों के बारे में पूछा जाए कि टाटा कंपनी के सबलीज के सभी प्रस्तावों को अनभिप्रेत की सहमति प्राप्त. एंड देन दे टुक अ स्टैंड बिफोर द रिट कोर्ट दैट दे हैव constituted an inquiry committee and it is being inquired. When this order was passed, that was under challenge. Your ladyship may see, my lord. Page 164 because this letter itself was under challenge. Yes. To just show the prayer. In this writ petitions, petitioners have prayed for quashing of the letter dated so and so, issued under signature of Principal Secretary, Department of Revenue and Land Reforms, Government of Jharkhand, and subsequently forwarded under memo number so and so.
That's where is the finding?
Here, this was an interim order to allow the construction, and then final
A
order.
detailed interim order was passed.
Yes, interim order was initially passed,
Yes,
allowing construction subject to undertaking.
that's right.
Then page 189 is the final order.
Yes.
205 is the final order. Page 205. From the affidavit filed in the
Yes.
present proceedings, I gather that there is no dispute insofar as recommendation of the appropriate machinery committee forwarded by the state government. The learned AG has submitted that communication of the approval of state government for sublease in favor of the petitioners has been disputed by the respondent on the ground that the said communication was not the decision. However, I find that it is not in dispute that petitioners were put in possession in several cases. Substantial construction has been raised. The direction not to carry further construction would necessarily follow civil consequences. In so and so, the Constitution bench, so and so, then civil consequences it
Yeah,
dealt
that's
with. Then in the writ para 15,
Yes.
in the writ petition, petitioner have taken up specifically that without affording opportunity of raising impugn letters were issued. In the rejoinder filed by the state, the plea of violation has been again reiterated by the petitioner to the pointed query. Then again violation, then para 16. I am of the opinion that insofar as the right of the state government to conduct an inquiry in the matter and examine the proposal for grant of sublease are concerned, the same cannot be challenged by the petitioner. However, there is no dispute that direction to maintain status quo and thus not to raise further construction has been without hearing the petitioner, though certain apprehensions were expressed. And the learned counsel for the respondent asserted that it is the company which is the house owner. Then less para 17. Accordingly, without entering into the merits, the writ petitions are allowed to the extent that if state government decide to conduct an inquiry in the matter, the same shall be completed on or before 31st March, which was extended up to 30th June. That order is also there. Pass a final order.
You read this, the apprehension expressed, page number 207, bottom.
Yes. The apprehension expressed from the state of Jharkhand is misplaced and founded on ignorance principles. In the first place, there is no restriction in the impugn letters prohibiting the petitioner from creating third-party rights. It is also well settled that an alienation of right, title or interest in the property would be binding only to the extent of right conferred upon the lessee sub-lessees. Accordingly, without entering into the merits of the matter, the writ petitions are allowed to that extent and so on. And this
So
time,
whatever ultimately happens to Tata lease, you are bound by that. And
sublease.
even for Tata lease, for that
Main
that
lease.
has been
Main lease, of course, main lease goes, we all go.
अब तो खत्म हो गया.
नहीं कहाँ खत्म हुआ?
मतलब अभी कंटिन्यू कर रहा है, उसका
हाँ.
डिस्प्यूट खत्म हो गया कि अभी भी चल रहा है?
नहीं अभी नहीं चल रहा है, वो तो हर गवर्नमेंट आएगा वो डिस्प्यूट करेगा फिर थोड़ा दिन बाद रिजॉल्व कर देगा.
Yes, this is how it works
हाँ.
for Tatas, right? Anyways, as on date there is an existing Tata lease. As on date there is a clause for sublease. As on date all the formalities which in connection with the lease has been done. You have done the necessary payment. The payment goes to whom? Tatas?
To the state government.
To the state government.
Through Tatas.
Through Tatas. It goes to the state government.
Yeah.
They have taken the money.
And regularly taking money.
Regularly taking money. And constructions are there. But in absence of a duly executed registered lease, you are not able to enjoy the property up to the fullest.
To the fullest.
And if the lease period expires, then your right to renewal arising out of that is also under clause.
Yes, which is otherwise there in the lease.
Which is otherwise there. So the document would become enforceable only when it is registered, the terms and conditions.
Yes. Now, my lord, like in the case of which was decided by the coordinate bench,
Yes.
in that case, my lord, half construction was done, and the map, my lord, still, the renewal of the map was not granted. So there, the direction is also to renew the map, because the building is half constructed, standing in a dilapidated condition.
There is a direction to register the lease.
Yes, that's there. Leadership may kindly see. Under the para 40, last page.
Yes.
Under the circumstances and for the reasons discussed above, both the writ petitions succeed. Tata Steel is directed to execute registered sublease in favor of the petitioners for the land in question, regarding which consent had already been accorded by the appropriate machinery committee, And in this case, further Jamshedpur notified area is directed to accord approval of the revised building plan as per the rule and in terms of the sublease. Needless to say that the order of status quo communicated with regard to it will not come in the way for execution of this.
So, lease has been executed but not registered.
Not registered.
Or agreement of lease has been executed.
Agreement of lease, possession, everything is there. Only the registration, formal registration of the lease is
What
not
would
there.
be the difference between an agreement of lease and a lease itself?
It will become a tenancy month to month. Otherwise, an agreement to lease for 30 years has to be registered in terms of the Registration Act.
That's no, it is one thing to say that the agreement of lease is to be registered. It is another thing to say that the lease by itself is required to be registered. There can be a lease deed executed between two parties for a period of 30 years, but it is registered at a later date. Maybe that after 1 year it is registered. That is
So it has to
permissible
take
under law.
effect from that date only. I am not asking from today 30 years. Like there are several properties which are lease properties. So if the agreement to lease is there, possession is there, to write under transfer to transfer of
So
property.
which is that document which you wanted to be registered? Which is that document?
Yes, that's there.
You want registration of which document?
The sublease document.
Which is that? Where
Yes.
is that?
Annexure 11, page 115.
One month.
115.
Just a minute.
So this was initially which was there. So now certain formal amendments which will be required to be done. That will be required to be done.
No amendment would be required. It will take its effect from the date it is executed.
Yes, of course. To that effect only, once it is registered, from the date of the agreement it will take its effect. And for the period which is already mentioned there.
You see clause 1.3, 1.2 and 1.3.
After final resolution by the state government and the competent court of law of the issue of quantum of rent, the deed of sublease shall be executed by and between the parties on payment of sublease of appropriate stamp duty as would be applicable there.
So this is not the document which is going to be registered.
But I am saying a proper. This is an agreement to sublease. The period and other things will be required to be in the when it becomes a sublease document. Then it has to be appropriately amended. I am not saying.
This agreement is only till execution and registration of the deed.
Yes, so my prayer is not to register this document. My prayer is to complete the formality pursuant to the sublease. Prayer number 3. and in fact, specific prayer is to execute a formal sublease and that's the coordinate bench direction also to execute a sublease. I am not saying annexure 11 is to be registered.
Tata Steel is a party. कौन है आपके सुनिए? आपको एडजमेंट देंगे 50,000 रुपए कॉस्ट, 50,000, नॉट लेस देन, नॉट अ पेनी लेस देन 50,000। इतना देर से बहस हो रहा है, क्या कर रहे हैं? यस, टाइम देंगे 50,000 रुपीज कॉस्ट देंगे, इससे कम में नहीं होगा। कब का टाइम चाहिए बताइए? बताइए। हाँ, कॉस्ट नहीं हटेगा, टाइम आपको चाहिए तो 50,000 रुपीज कॉस्ट आपको जमा ही करना है, नहीं तो इसको आप डीबी में चैलेंज कर सकते हैं और आपको जहाँ जहाँ मन हो चैलेंज। आई एम हियरिंग दिस मैटर फॉर ऑलमोस्ट 45 minutes. And when I call upon you, you say that your senior is not there and you are seeking time. क्या ही जरूरत है? टाटा स्टील को पैसे की कमी थोड़ी है। Litigation is a luxury for you, isn't it? You have to deposit cost. I will not adjourn you. Otherwise, I will record your absence. चॉइस बताइए क्या है? हाफ अ मिनट के अंदर, तब तक हम स्टेट का कहानी सुनेंगे। आधा मिनट के अंदर हमको बताइए कि आपका एब्सेंस रिकॉर्ड कर दें या आपका प्रेजेंस रिकॉर्ड कर दें by saying that you have nothing to say because your senior is not here, or you want to deposit cost of rupees 50,000. बार्गेन मत करिएगा, 50 को 1 शून्य बढ़ा देंगे, ठीक है? ये स्टेट what do you have to say?
Yes, my lord. My lord, the pursuant to the order of status quo filed with the DC, my lord, the year 2012, a batch of writ petition was filed before the honorable court. After disposing of the, my lord, that batch of writ petition, it was ordered that if the state government wants to conduct an inquiry, my lord, that will be conducted, and the time frame was given. But within that time period, the inquiry was not conducted. Thereafter, time was extended, my lord, the inquiry was conducted. We have brought on record the inquiry, my lord, which was conducted by the state government. It was found that without executing registered sublease, my lord, the delivery of position was transferred to the third party, creating third party debt. Since Tata Steel was the leaseholder, my lord, if
पैसा दिए कि नहीं?
it was deposited before Tata Steel, my
You
lord.
have taken the money?
No, it was before Tata Steel.
No, ऐसा नहीं है इसमें। ऐसा थोड़ी है कि टाटा लीज पहली बार
That is what, my lord, that has been stated in the inquiry report. Despite submitting before the state government, they have submitted before the Tata Steel. That has come in the inquiry report. And they are saying that through channel they before the state government they have to deposit before Tata Steel for depositing before state government. It is not, my lord, they have to
You have filed
directly.
your counter
Yes, my lord, we have filed the
and
counter.
you have stated that the amount has not been deposited to
In
you.
the inquiry report also, my lord, it has come. We have annexed that inquiry.
Okay. Where is the clause in the Tata lease that the amount has to be deposited to the state government directly? तो आप अपने को ये वाले वीक में आपने ऐसा कुछ प्ली लिया? इस वाले वीक में इंक्वायरी रिपोर्ट लगाया? ये जो पुराना जो वीक है जिसका एलपी आपका डिसमिस हो गया।
In that writ, my lord, it was submitted by the petitioner that inquiry is not conducted. But inquiry was conducted in the year 2015 only.
Completed.
Yes, my lord.
Why did you seek extension of time?
Because, my lord, the time was given up to
Extension
I'm-
कब हुआ है?
I am submitting, my lord.
Extension कब हुआ है? Date of
Yes,
extension
my lord, I am
बताइए।
saying. Up to 31/3/2015, the inquiry has to be conducted and the matter was disposed of. By 31/3/2015, the inquiry was not conducted, but the matter was disposed of. A CMP was filed for notification for extension of time. Time was extended and the inquiry
Extended till
till, my lord, till 31/6/2015, my lord. In the month of May, it has been completed.
31/6/2015.
Yes, my lord.
Where is the
38.
inquiry report?
Inquiry report is in annexure A of the counter affidavit filed on 9/4/2024. So within the period, my lord, the inquiry was conducted, but in Ashiana, my lord, it was perhaps submitted that it was not completed. That was the judgment of 2023. It was completed in the year 2015 only. They have brought down report by way of filing the counter on 10/4/2024.
Where is your abovement and then we'll see that.
My lord.
4/4/24. Counter affidavit and
10/4/24,
response.
ma'am.
Sorry?
10/4/24.
On behalf of respondent number 1 to 4.
1 to 4, yes, ma'am.
यहाँ पे 9/4 लिखा हुआ है 10/4 का फाइलिंग होगा.
My lord.
बताइए पहले स्टेटमेंट बताइए
Yes.
उसके बाद.
Yes. Lord, kindly come to page 11 of the counter 9/4/20, para 14. Para 14, 16, 17.
Just a minute. पढ़िए पैरा 14 से पढ़ना शुरू करिए.
That it is further most humbly and respectfully stated and submitted that letter dated 22/9/2012 was issued to the petitioner by Tata Steel Limited enclosing therewith letter dated 21/9/2012 of Deputy Commissioner, letter dated 18/9/2012 issued by the Commissioner, and the letter dated 17/9/2012 issued by the Principal Secretary, Revenue and Land Reforms Department for maintaining status quo in the light of certain irregularities committed in the matter of grant of sublease and also in the light of report submitted by Shri Devashish Gupta, the then member Board of Revenue. Number para 15. That is humbly stated and submitted that petitioner has filed WPC number 6199 of 12 challenging the above said letters of for maintenance of status quo and for the stoppage of construction activity. Later on, the matter was heard on and by order dated 7/3/2013 and interim order was passed by the Honorable Court directing the petitioners to carry out further construction in respect of their subleased area, subject to their undertaking that the construction activity would be carried out by the said petitioner at their own cost and risk, and they will not claim any equity on that account. Now, my lord, that it is humbly stated and submitted that above said writ petition by WPC 6199/12 was heard on decided by the Honorable Court on 17/12/14, whereby it has left open for the state government to conduct an inquiry in the matter and to complete the same by 31/3/2015. Now, my lord, extension. Humbly stated and submitted that pursuant thereto, the inquiry committee was constituted and show cause notice was issued to the petitioner.
Where is the show cause to the petition?
Show cause notice to come and cooperate in the inquiry, my lord. They have, that is stated, my lord. So thereafter,
So you issued show cause notice to the petitioner as well,
yes, my
or
lord.
you issued show cause notice only to Tata Steel? We'll see that.
Yes,
आगे
notice
proceed.
was issued to the petitioner. It was issued to the petitioner. And by order dated 8/4/15 passed in CMP number 118 of 2015, the time for completion of the inquiry has been extended up to 30th June 2015. Thereafter, it is humbly stated and submitted that inquiry committee has conducted the inquiry and completed the same after properly considering the show cause reply, the facts and circumstances available on record, and every other formalities. Thereafter, the same was sent to Revenue and Land Reforms Department, Government of Jharkhand by memo was also dated 21/5/2015. So this is the annexure A, man, the inquiry report.
And what is the gist of the inquiry report?
It was found that my lord, without executing registered sublease,
Okay. Just a moment.
that is the gist of
It was an agreement of lease, correct?
my
Does it require registration?
without registering
Agreement of lease, does it require registration?
for delivery of possession, my lord, it requires
What is the
registration.
consequence of an agreement or unregistered agreement of lease?
Consequence, my lord, it cannot be delivered, my lord. The question cannot be given.
कहाँ से lawyer?
That has come in the inquiry without
आपके इंक्वायरी रिपोर्ट तो आपके ऊपर बाइंडिंग है, मेरे ऊपर बाइंडिंग नहीं है ना.
without
You have to show the law. You have to show that what is the violation.
violation of 107 of Transfer of Property Act, my lord. That has come in the inquiry.
That without a registered deed of lease,
My lord.
you cannot deliver possession.
My lord.
Like 107 transfer penalty. सुबह यहीं पर ये रहा पढ़िए कर
Lord, kindly come to the inquiry report, Lord. The reference of 107 is given in that inquiry.
और
That will
किताब से नहीं देखना 107
be without execution of registered sale.
किताब से भी देखेंगे ना 107 के इंक्वायरी रिपोर्ट देखेंगे बस फर्स्ट विल सी द लॉ उसके बाद विल कम टू योर रिपोर्ट आपका रिपोर्ट बिना कंसीडर किए थोड़ी ऑर्डर हो जाएगा 107 उनको एक और दीजिए भाई हर एक्ट का 3 सेट रखा करें हम आपको बार बार बोल रहे हैं वकील साहब किताब लेके नहीं आए ना हम जानते हैं आप नहीं लेके आए
I have given Malad soft copy.
चलिए, हाँ बताइए 107
Yes, Lord. Lease how made? Edit.
Lease of the property from year to year or for any term exceeding 1 year or reserving a yearly rent can be made only by registered party.
That's right. It is not a lease, it is an agreement of lease.
So regis-
Agreement for lease.
only by way of registered instrument.
यही तो हम इनसे पूछ रहे थे what is the difference between an agreement
Unless-
of lease and a lease are not one and the same document. Are not one and the same. You see what they have executed? पढ़िए पेज नंबर
One 121.
120 क्या है पढ़िए जनरल आफ्टर रिसीट ऑफ पढ़िए
After receipt of approval of the state of Jharkhand by memo number so and so dated 8/6/2007, the sub lessee on 22nd August 2007 has deposited under protest the differential amount deducting rent and sales deposited by them for a different site with the government directly of the rent and 25% of rent as road sales with the company, which in turn has been deposited by the company with the state government in accordance with the terms of indenture dated 28/2000.
राइट जमा हो गया स्टेट के पास है ना आगे पढ़िए
Upon receipt of the money as opposed the company has on 27th day of August 2007 put the sublease in possession of the land described broadly in schedule there.
आगे आगे पढ़िए
After final resolution of state government and or the competent court of law of the issue of quantum of rent and cess, the deed of sublease shall be executed by and between the parties on payment by the sublessee of appropriate stamp duty and registration charges as would be applicable.
आगे पढ़िए
Validity of the agreement. This agreement shall be deemed to be effective from 27th August 2007, that is the day of handing over the possession. The agreement shall remain valid till execution and registration of the deed of sublease on 31st 2025, whichever is earlier.
पढ़िए
Of the
So this agreement only says that yes, there is no legal bar in getting a deed, a lease registered with a retrospective date. ऐसा कोई बार है कि भाई आज कोई एग्रीमेंट बनता है we can this agreement be registered after 1 year giving effect to it with effect from today? Possible or not possible? This is just an agreement of lease, not the lease by itself. The amount has gone to the state government.
yes.
Is there any condition? Where is that document? ये जो दो document इसमें refer किए हैं, is it a part of the record? This is 8/6/2007 and 27th of August 2007.
Yes.
वो देखिए. Let us see.
Statement given.
8/6/2007 and secondly.
Annexure 10.
Annexure 10 is 27/8/2007, my lord, but 8/6/2007 statement is given regarding the 8/6/2007.
Where is it?
Para 18 one of the statement is there. In fact, 14 onwards, if I read it, the approval which was granted and then the value was also directed to be deposited to state government. May I read
Yes,
from
yes, yes, it is there.
that the state government by its order number so and so dated 14/6 granted 3.12 acres of land to the petitioner, fixing the annual commercial rent of the land at 5% of the total value of land at rupees 12,16,000 only. Then that it is stated that by letter dated 19/6/2006, the Deputy Commissioner E. Singh Jamshedpur directed the petitioner to deposit the commercial rent of rupees itna along with cess amounting to rupees itna only. That by letter dated Deputy Commissioner E. Singh observing that the petitioner had deposited
ये
around
ये दिखाई देगा.
yes, that actual
Annexure 7. Show me Annexure 7.
at page 110.
हाँ पढ़िए. इसी को पढ़िए.
महाशय उपयुक्त विषय प्रासंगिक पत्र का कृपया निर्देश करें. प्रासंगिक पत्र के आलोक में श्री सो एंड सो द्वारा दर पट्टा पर स्वीकृत जमशेदपुर अधिसूचित क्षेत्र समिति वार्ड नंबर 6 के अंतर्गत खाता नंबर 2 प्लॉट नंबर 13 अंश सो अंश रकबा सो एकड़ 0.5 एकड़ एंड 0.99 एकड़ कुल रकबा 3.12 एकड़ भूमि का राज्य सरकार द्वारा निर्धारित.
बताइए, इसमें आपको डायरेक्शन है हैंड ओवर करने की. पढ़िए Annexure 7. Is it a disputed document? Yes.
Not the objective.
There is a direction to hand over possession. Correct? दखल देहानी सुनिश्चित करे राजस्व की क्षति नहीं हो जाए. रादर इन्होंने तो थोड़ा लेट से हैंड ओवर किया है. राजस्व की क्षति हो गई होगी. आप करेक्ट?
Lord, the objective of the agreement, my lord, here in this case, my lord, in Annexure 7, my lord, the sublessee would be the multiplex and the commercial units. The objective of, my lord, giving sublease is for the purpose of residential and other amenities like.
आपका अप्रूवल है कि नहीं है?
Yes, my lord.
डायरेक्शन है कि नहीं है हैंड ओवर करने से? देयर इज अ क्लियर एग्रीमेंट कि भाई आप रजिस्ट्री करेंगे. रजिस्ट्री करें. यू सी देयर आपको समझ नहीं आ रही बात.
My lord,
अगर रजिस्ट्री नहीं होती है ना तो इनको राइट ऑफ रिन्यूअल नहीं मिलेगा. सारा कहानी वहीं पर है. समझ आएगी कि बात? दे विल कंटिन्यू. आप एक चीज समझिए.
my lord, in the document,
they will continue to be month to month tenant. आप उनको कभी evict नहीं कर पाएंगे. At the time of renewal, you can always say कि भाई अब हम नहीं बढ़ाएंगे. 5 साल के लिए बढ़ाएंगे, अब नहीं बढ़ाएंगे. कहानी खत्म. बोल सकते हैं ना? लेकिन जब मंथ टू मंथ टेनेंट बन जाएंगे तो कैसे हटाइएगा? प्लीज एग्जीक्यूट कर दीजिए. आप ही का है डायरेक्शन हैंड ओवर. कुछ और बोलना है इंक्वायरी रिपोर्ट में?
No, my lord, in the document, delivery of position is direction is given for delivery of position
Yes.
and in the inquiry report they are saying that. So it is-
कहाँ है? दिखाइए आपका इंक्वायरी.
Same complement, 9/4/2024. Page 28 onwards.
कहाँ लिखा है?
Page 28 onwards.
हाँ वो तो हमको दिख रहा है 20 onwards.
Para 5, page 37. Certain paras are there. Paras are 5, 7, 10.
निष्कर्ष पढ़िए तो. प्रोजेक्ट का क्या नाम है?
PNM.
अच्छा, ये सारा निष्कर्ष इन्हीं से रिलेटेड है।
Para 5, page 37. Next page of discussion.
पढ़िए।
Para 5.
हम्म,
ट्रांसफर ऑफ प्रॉपर्टी एक्ट 1882 की धारा 107 के आलोक में टाटा स्टील द्वारा P&M इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड के साथ रजिस्टर्ड सबलीज एग्रीमेंट निष्पादित किया जाना था। टाटा स्टील लिमिटेड द्वारा दिनांक 7/3/2008 को P&M इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड के साथ 500 रुपए के स्टैम्प पेपर पर रजिस्टर्ड एग्रीमेंट फॉर लीज निष्पादित किया गया। तो एग्रीमेंट फॉर लीज की कंडीशन 1.3 में उल्लेखित है कि आफ्टर फाइनल रेजोल्यूशन विद स्टेट गवर्नमेंट and or the competent court of law of the issue of quantum and rent and sale, the deed of sublease shall be executed by and between the parties on payment of subleasee or applicable stamp duty and registration charges that would be applicable there. Number of para 7, page number 40. टाटा स्टील लिमिटेड द्वारा P&M इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड के साथ रजिस्टर्ड सबलीज एग्रीमेंट एग्जीक्यूट किए बगैर प्रश्नगत भूमि का डिलीवरी ऑफ पोजीशन P&M इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड को दिया गया तथा P&M इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड के द्वारा उक्त भूमि पर मल्टीप्लेक्स सिनेमा हॉल एवं शॉपिंग मॉल का निर्माण कार्य कराया जा रहा है। नंबर पैरा 10। टाटा स्टील लिमिटेड द्वारा एवं P&M इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड के बीच रजिस्टर्ड सबलीज डीड एग्जीक्यूट नहीं होने के फलस्वरूप ट्रांसफर ऑफ प्रॉपर्टी एक्ट 1882 की धारा 107 के आलोक में P&M इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड को सब लीज राइट्स ट्रांसफर नहीं हुए। P&M इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड द्वारा
You
सब
see, there is no legal bar in executing a deed which is exceeding 11 months. The only consequence is that they will be treated as month-to-month.
Yes, madam.
And no clauses of the lease deed can be considered. And here you have yourself issued letter for delivery of possession. उसको dispute नहीं किया ना वो letter को, कोई document तो नहीं फाइल किए हैं petitioner.
That is the document of invalid petition, but no document.
हो गया? So it is covered now.
He was referred, madam, that has been dismissed on the documentation.
उससे क्या? इसीलिए ना, क्योंकि उसमें लिखा हुआ है कि रेजिडेंट काटा नहीं लगेगा।
Yes, madam.
इसीलिए तो
That is-
स्पीकिंग ऑर्डर होना चाहिए ना, considering this report, that your primary objection is that possession has been handed over without without registering the lease, right? ये भी लिखेंगे कि भाई इस तारीख को इनका पीरियड भी एक्सपायर कर रहा है। This is very much apparent on the face of it. They can't deny of it. Whatever it is. आपका रिन्यूअल का बात आएगा, ये क्लेम करेंगे तो आप अपना रिन्यू करिएगा, चाहे मत करिएगा, चाहे जो करिए, आप तो राजा हैं। इनके बिना मिले तो आप रिन्यू भी नहीं करिए, कर लेंगे क्या? हाँ, इस बार ये ऐसे थोड़ी रिन्यू कराएंगे, सूट फाइल करके रिन्यू। ना जीते हैं ना जीने देते हैं, है ना? यस, हो गया। टाटा स्टील को कुछ बोलना है?
Same matter as
Same,
Ashwin, I
same.
believe.
नहीं, in Ashiana the report had not come. In Ashiana the inquiry report had not come. Here they have filed the inquiry report, so this inquiry report requires a consideration.
It does. The consequences of the inquiry report cannot ensue here. That's what I'm saying. The inquiry report was submitted to the state government. The state government has to act on it.
You see, the inquiry report is primarily mentioning the objection that without registering the lease deed, the possession has been handed. And there is a letter of the deputy commissioner to immediately hand over the possession such that there is no loss of revenue.
Because in Jamshedpur, the entire registration is stopped. For I don't know how many years, there's no registration happening in Jamshedpur, in the city of Jamshedpur.
In sublease, no?
In the sublease. Earlier, what used to happen is that they used to register the portion of the constructed area. Now that is also stopped. That has also stopped. Some Jamshedpur area, there is no generation of revenue from stamp duty and registration charges. Whereas there are prime properties in Jamshedpur, there is no valuation. All these things, the state is losing out on revenue, there is no doubt about it, and people are losing out on their revenue, there is also no doubt.
And those who want to get revenue and get it registered,
They
state
don't
is
want that.
objecting to that.
How does it make a difference? Even there is a registered document today, and the entire thing is held to be banned. Registration will automatically go. Nothing will happen. State does not lose out, but yes, registration is important for my learned friend to take financial assistance.
Not only financial assistance, renewal is an important
Yes,
one.
yes, yes,
You
certainly.
see, if we see it from both angles, whenever there is a fixed term lease,
Yes.
right, there is a scope for denial of renewal, or they can always say that this renewal is for the last time, we will not extend it any further. Suppose 5 years they extend, or 50 years they extend, that's it, this is last renewal, we will not extend it anymore. But if there is no registration, the status is month to month tenancy,
Yes.
and nobody can evict them because they will never be defaulted in payment of rent.
There is no question of.
So they don't know their own interest. खुद ही नहीं पता.
Thereafter, the order status was passed.
और आप नहीं कर पाएंगे, ये भी नहीं कर पाएंगे, किसी को evict कर ही नहीं पाएंगे.
The mall is in place, so many shops are running in that place, all these things.
And actually, lot of those who had expedited and done construction, maybe out of their own funds or otherwise, they are running, but
And-
most of them are
And
half
you see, since
constructed
we
and lying
belong
like
to
that.
the state of Jharkhand,
Yes.
we know what is happening. These properties, इसमें वो नहीं हो रहा है, लोन नहीं मिल रहा है,
नहीं मिलता,
नहीं मिल रहा है।
दिक्कत है मेरे को।
फाइनेंस नहीं फ्लो कर रहा है.
नहीं कर रहा, that's what-
Economy is not booming as it should have otherwise boomed.
It is not. It is not.
And it is a fact, Manoj, some people have been able to construct, maybe they had finances. Rest, out of 59, I think 50 are still vacant, half constructed,
You see, we
something
are
like
just
that.
discussing what is the consequences,
Yes,
but we'll go strictly by the records. Your objection is that they have handed over possession without registration, and there is already an order passed by the deputy commissioner to hand over the.
Thereafter, my lord, the order status was passed. That was in the year 2006, my lord.
That's right.
Order was passed in the year 2012.
And they are enjoying the
Status
property.
quo has merged with the final order.
Yes. So thereafter, my lord, the further development has taken place. The report was of the year 2015.
पूरे 4:30 बज गए,
हाँ।
अभी आज नहीं लिखा है. चलिए. All the learned counsels appearing on behalf of the parties. The learned counsel for the respondent, the petitioner has submitted that the case is fully covered by the judgment passed by this court in the BPC number 529 of 2019, wherein a direction was issued to execute registered sublease in favor of the petitioners of that case. He also submits that appeal filed against this judgment has been dismissed, though only on the point of limitation, and the plea of res judicata, and it has also been observed that the plea of res judicata will not be available with respect to other cases, if any. The learned counsel for the respondent state has submitted that the report of the inquiry committee was not available in WPC number 529 of 2019, and in the present case there is a report which has been annexed along with the supplementary counter affidavit. The learned counsel has also submitted that the primary objection of the state is that that Tata Steel had handed over the property to the petitioner without any registered document of sublease. In response, the counsel for the petitioner has referred to Annexure 7 to the petition and has submitted that the entire payment has, as per the letter itself, the entire payment has been remitted, and a direction was issued to hand over the possession of the property, such that there is no loss of revenue. This is the last letter, no?
Yes.
इसके
Then-
बाद जो चेंज हुआ था वो पहले का कहानी है.
नहीं, ये फिर एनेक्शन 9 भी है, पेज 112. वो फिर मेरे को बोले this is dated 30th June 2017 and they specifically say that इकरारनामा for sublease करा लेना होगा within 3 months. Yeah, that is the change.
The Learned Council has also submitted that subsequently the allotted land was changed and additional amount was directed to be deposited. For this purpose, another letter dated 30th June 2007 was issued. इसमें तो लिखा है कि आपको कराना होगा within 3 months.
Agreement to lease.
निबंधन कराना होगा. The said document is contained in Annexation 9 to the
सबलीज निबंधन का इकरारनामा कर लेना होगा. Page
सबलीज
100 निबंधन का इकरारनामा कर लेना होगा.
अच्छा
मतलब to enter into a sublease, registered sublease, I have to enter into an agreement कर लेना होगा.
we'll see this thing.
And then Annexure 10, page 114, Tata Steel pursuant to this direction of the state government handed over to possession boards.
He submits that ultimately the possession was handed over by the Annexure 10 and the reading of the aforesaid documents revealed that the possession was handed over in terms of the directions issued as contained in letter dated 23/6/2006 read with letter dated so date बताइए
30th June 2000.
38 June 2007. The Learned Council has also submitted that there was a clear indication in the letter dated 23/6/2006 to hand over the possession so that there is no loss of revenue. He has submitted that by the act of Tata Steel, the respondent hearing, appropriate steps were taken to hand over the possession and thereby the private respondent has taken care of the loss of revenue. Correct? यही है? और कुछ बोलना है? आपका तो सबमिशन लिखा है? Learned Council appearing on behalf of the private respondent had supported the submissions made by the Learned Council for the petitioner. इतना ही आपको बोलना है? Appearance लीजिए. The court time is over. Post this case for further hearing ही लिख रहे हैं. वैसे हम दिखाएंगे भी, ठीक है? और further hearing. कल कोई टाइम देख लीजिएगा. कौन सा टाइम आपको कुछ बताइए? आप लोग इतना बिजी
I will be there.
बताइए.
Anytime your worship fixes some.
12:30. ठीक है? यस मिस्टर अरविंद कुमार कहाँ है? बताइए, आपके केस में तो कुछ नहीं है।
कल सवा 2 बजे
कल 2:15 नहीं रखेंगे, कल 10:30 बजे पहले
10:30 बजे कुछ बिल मैटर से लगा
डिसमिस कर देंगे आपका केस।
सवा 2 बजे हम आज भी बैठे हुए थे।
आज बैठे हुए थे तो आपको बैठे रहना चाहिए था ना, आप पास ओवर लेके।
दूसरे कोर्ट में केस
भाई आप बहुत बिजी काउंसिल है, आपका केस तो एट ए टाइम कई जगह कॉल आउट हो।
आई एम नॉट कल सवा 2 बजे
नहीं।
का 10:30 में
choice।
10:30 में ये है कि 10:30 में लगभग कुछ बेल मैटर लगा हुआ है वहाँ पर क्लाइंट
अभी बहस करें, अभी बहस करें। कल आप बहुत बिजी हैं, अभी तो किसी कोर्ट में नहीं जाना, 4:30 बज चुका है। आज भी वेयर केस, बाकी लोग जा सकते हैं, बस इन्हीं का केस सुनिए। चलिए
suit for partition has been filed. On the ground, they said that there was no partition by means of either through registered deed or by the court. There is no partition. The case of the contesting defendant is that there was a Ansnama agreement executed in 1940, sometime in 1940, between the four brothers, in which there was only with regard to Jharkhand we have challenged that 1 acre 18 decibel has been extra land has been allotted to him on the basis of that family arrangement
let
being
me
a
just pause
Jharkhand.
here for a moment.
This one judgment.
The agreement, the suit was not for partition of the entire property.
Yes. Suit was
So there was an admitted fact that there was partition.
no, with regard to that property there is no such
So
partition.
therefore, you see, the entire joint family property was not subject matter of partition,
Yes.
right?
Yes.
And you also claim that there was partition.
There was with regard to some other property there was a partition. With regard to this property Sandariya, that
This was given by way of Jharkhand.
by the mother, and the case of the plaintiff is that the mother was alive. That was the share of the mother while she was living with the elder brother. It was given. After death, there is no such provision for Jethans. There is no such provision for Jethans. That said.
उस समय भी नहीं था क्या जब हुआ था partition?
नहीं, उस समय भी कोई नहीं था. There is one judgment of the Supreme Court of Supreme.
1968.
Yes. That.
बताइए क्या है इसमें केस?
Para 6.
पढ़ी. पढ़िए पैरा 6.
Para 6 में, we pass on to consider the next question asking arising in this appeal, namely whether Hem Kumar was entitled to a greater share of a joint family properties for the reason that he was the eldest brother on the principle of Jethans. But the doctrine of Jethans or Jethans is now obsolete and
Now obsolete ना?
Yes.
तो ये जब जजमेंट हुआ इस वक्त पार्टीशन सूट
ठीक है, but there was no
it does
partition.
not nullify it.
Yes, but there was no partition by either. Partition will be either by a competent court or by a registered deed. There is no partition of such, and there is
It was not your case that there has been no partition.
Yes, we have said there is no partition.
If there was no partition, then how can you say that this property was allotted to by way of Jethans?
No, we have not said that it is by way of Jethans. They are positioning as a Jethans. They are claiming that this property has been given. The defendant is claiming, contesting defendant, that this property has been received by him being a Jethans.
There was a partition suit earlier also.
No
There
partition.
was a suit earlier.
Suit that is under Santhal civil law before the SDO. Lord, that is exhibit F1, Lord, in which when the after death, when he was posted from that property, Jethan's property, for restoration he has filed.
आप जरा देखिए पेज नंबर 21 में आइए.
Case
21. Internal page 11 of the trial court judgment. नहीं, of the appellate court judgment.
yes.
Bottom में आइए. पढ़िए. बाद में सखी सिंह. पढ़िए.
Lord, वह पक्षों के विद्वान अधिवक्ता दिस.
ये बॉटम में एकदम लास्ट लाइन में.
Yes.
बाद में सखी सिंह.
वाद में सखी सिंह को प्राप्त जेठान जमीन से 1 वर्ष के में ही मोती सिंह, नूनराम सिंह व शालिग्राम सिंह ने उन्हें बेदखल कर दिया, जिसके उपरांत सखी सिंह ने उन लोगों के विरुद्ध स्वात्ववाद संख्या 39/1941 दाखिल किया, जिसमें अनुमंडल दंडाधिकारी देवघर के न्यायालय द्वारा सखी सिंह के पक्ष में निर्णय दिया गया. Below that your lordship finding can be verified from the document. उक्त निर्णय के विरुद्ध मोती सिंह ने पुनः स्वात्व अपील वाद संख्या 1600 किया, जिसे RRP सिन्हा अनुमंडल पदाधिकारी देवघर के न्यायालय द्वारा दिनांक 4/6/1943 को खारिज कर दिया गया और सखी सिंह का दाग नंबर 31 में 1 एकड़ 18 डिसमिल जमीन पर जेठांस के न्यायालय के फैसले को संपुष्ट किया तथा उस आदेश के विरुद्ध वादीगण की ओर से या अपीलकर्ता की ओर से ये माननीय उच्च न्यायालय या उच्चतम न्यायालय में द्वितीय अपील नहीं किया गया है. इस संबंध में उत्तराधिकरण
There has been a litigation in connection with it.
yes
And
thereafter they filed
he was dispossessed.
Yes.
He was granted possession.
but that position was not given. Now in 1958-59 they have applied for the Sakhi Singh's legal heirs has applied for
No, that
mutation.
is a separate mutation, etc. is a separate thing
Then
altogether.
in that mutation,
No,
Milord, it has said
but there has been a litigation
Yes,
in connection
that
with it.
Milord-
That litigation has attained finality. There is no substantial question of
Milord,
law. Please
that
don't
was
tell
not
us.
with regard to any partition of share. Milord,
No,
If-
this was directly in connection with Jethan.
that order passed in that 1941. Small order is there, 3-page order is there.
39 or 41.
Yes.
That was not in connection with Jethan.
That is disposition का है उसी का
Disposition by Jethan's
it is
right,
no it is
disposition.
under संथाल सिविल लॉस में
So
हुआ था
what?
कि हम पोजीशन
संथाल civil law-
उसको
संथाल सिविल लॉ में ये सारे ऑर्डर्स
the
बाइंडिंग है
principle of
parties
res
के ऊपर.
judicata will not apply here.
Or
It is
you
not.
say why it will not apply here?
The issue was different. If you
No, no.
ladies if I verify that order from that
I
order.
verified it, and this particular judgment does not say that whatever has happened earlier will be undone.
But there was no partition by meets and bound
Need
anywhere.
not
No.
be. You see, जब भी partition होता है, कोई जरूरी नहीं है सबको बराबर share.
बराबर की शेयर का नहीं कर रहे हैं, but it is not by court, competent court,
Need
or
not
by a registered
Need
deed.
not be.
But it
Need
is
not be.
it was just a answanama. It is in 3 parts. Answanama is in 3 parts. Exhibit E1.
There is concurrent finding about the partition amongst yourself with all, and you see, you have filed case only in connection with Jethans. For the rest of the properties, you have not
No,
filed.
we have
any
filed
case.
for 1/3.
One-third of
1/4 of this.
Jethans
Not
only.
only Jetans, entire property. Suit for entire
No,
property
no.
except 2 properties which were of father village where leave was taken. Milord, leave was taken. That leave was para 4 of the plan. Leave was taken with regard to the property. Small property was there on outside. That was except that 1/4 share they have claimed in the entire property. They have not only that Jethan's portion. Jethan's portion we are saying that such allotment is wrong.
No, there is a finding that you have, the subject matter of the property is only the Jethans.
No,
Yes.
suit is for may I read the plan.
No, you don't need to read the print, you just illustrate. जेठांस का प्रॉपर्टी डिस्क्रिप्शन क्या है?
That is JB number 31, area 1 acre, 18 days.
Only. Heard the learned counsel appealing on behalf of the appellant. The learned counsel for the appellant has submitted that the appellant is only aggrieved by the allocation of Jethans to the eldest brother named Sakhi Singh, which was in relation to plot number 31, area 1.18 acres, 18 decimal. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in AII 1968 SC 1299 paragraph 6 and has submitted that it has been held that the concept of Jethansi is now obsolete and unenforceable. The learned counsel submits that this second appeal be heard on the point as to whether Jethans would have been allocated to the elder brother, namely Sakhi Singh, which happened sometimes in the year 1940. That's all. Arguments completed. अभी लिखा नहीं पाएंगे तो लिखाते हैं. हाँ लाइक.
Item 1 for judgment.
The impugned award passed by the Facilitation Council is quashed and set aside, and the matter is remitted back to the Facilitation Council. And the case number JHMSPFC 03/2011 is restored to its original file to enable the Facilitation Council to proceed in accordance with law. The petitioner as well as the claimant are directed to appear before the Facilitation Council on 11th of March 2025 at 11 a.m. Upon their appearance, the Facilitation Council is directed to proceed with the matter step by step in terms of Section 18 of MSMED Act of 2006, as indicated by the Honorable Supreme Court in the case of Jharkhand, Urja, Vikas Nigam Limited. This repetition is accordingly disposed of. Discuss. Date जल्दी करो date. मंडे का डेट है इसमें मंडे का डेट फॉर ऑडियंस जजमेंट नहीं अगर सब्सटैंशियल क्वेश्चन ऑफ लॉ लगेगा तो बना देंगे नहीं तो प्लीज डिस्कस कर देंगे